Good morning, folks, and thank you so much for joining us today for Liability and Legal Fundamentals. If you serve on a nonprofit board, it's important to become fully educated about the various liabilities as a director and the best risk management practices to mitigate any personal liability or challenges for the organization. This session for nonprofit board members and leaders will dive into just that. My name is Sandeep. I am the manager of education here at Integral Org, and my role today is to support your participation. So please don't hesitate to reach out to me. I'll be available in the chat throughout our time together today. I'll also be around to address any issues that you're having with tech, accessibility, but also if you have any questions for our facilitator today, I'll acknowledge those with a thumbs up so that I know that they're there. I've tracked them and we'll bring them back up in the Q&A period at the end. To support your accessibility needs today, you can turn on the closed caption feature on the bottom of the Zoom window. The live transcription option will help you follow along today's session. Please note that the closed captioning feature is available on the recording that you will receive of today's session as well. I'm going to drop a little bit more information about that for you in the chat right now. So this is just the Zoom Q&A page for closed captions and live transcription if you run into any challenges. Like I said, I'm also here to help you with that, so let me know if you have any issues. Yeah, your engagement is important to us. Like I mentioned, I'll be around in the chat, so feel free to drop your comments, questions, concerns as we move along. Once again, I'll like it just to acknowledge it. I may not address the question in the chat just because we'll give our facilitator a chance to circle back to that at the end here. Before we move on today, we will begin with a land acknowledgement. We would like to acknowledge that Integral Org is based out of Mohkinstsis, which is the Blackfoot name for elbow. This refers to the confluence of Elbow and Bow rivers that run through Treaty 7 territory. Mohkinstsis is situated in the traditional territory of the Blackfoot Confederacy, which includes the Siksika, Piikani, Kainai, as well as the Stoney Nakoda First Nations, consisting of the Chiniki, Bearspaw, and Goodstoney First Nations. Mohkinstsis is home to the Tsuut'ina First Nation and the Métis Nation of Alberta District 5 and 6 as well. At Integral Org, our team recognizes the existing tension between the legal and governance structures that we work within and efforts towards truth and reconciliation. We accept our responsibility to work towards reconciling this tension, and we recognize that we all have a connection and responsibility to the lands that host our lives, our communities, and our work. With that, I'm happy to introduce our facilitator for today's session, Yvonne Chenier. Yvonne is a lawyer and philanthropy consultant and co-founder of Integral Org. She brings more than 35 years of experience helping those in the philanthropic, nonprofit, and social enterprise sectors as general legal counsel and as an advisor on organizational, regulatory, and governance matters. Yvonne, thank you so much for being here with us today. I will pass it over to you.
Thank you, Sandeep. I hope everyone can hear me, and it's a pleasure to be talking to you all today on such an important topic. I'm going to give you a little bit of an overview of what we're going to be discussing, but I just want to emphasize that this is for charities and nonprofits that are based in Alberta, because I'm really going to focus on some of the unique aspects of our legal requirements for charities and nonprofits in the province of Alberta. So if you're listening from a province elsewhere or another jurisdiction somewhere else, much of what I'm going to say, it will not be specifically related to your organization. It's very important that you know what jurisdiction governs your organization at all times. That's one of the legal fundamentals of the organization that you are working with or volunteering for. So that's generally my overview on that very important topic, but I am going to talk about other legal influences on an organization. I'm going to give you a little bit of a background on what does influence an organization internally and externally. And then I'm going to talk about, based on those influence, what are the fundamental duties of the board of directors of those organizations. And because I'm talking about Alberta today, I'm going to talk a little bit about how you can be protected from those liabilities based on a piece of legislation that we have in Alberta called the Freedom to Care Act. And of course, you need to manage your risk as an organization, whether or not you are liable or not. So the directors and officers risk management topic and sharing some key resources will be the how we end the session before we take questions. So let's talk about a very high overview of what basic influences govern an organization like yours here in Alberta. And this is sort of setting the scene, so you get a flavor of where all of this liability comes from, where these things you have to manage actually come from. And they all come from influences that actually impact what your organization is or has to do. And this is really presented from a legal point of view because the fundamentals are always the first thing that any lawyer looks at before they can give you any specific information or advice about your organization. So the internal influences that govern your organization, and each organization is very unique. No two organizations really are the same if you look at all the influences that can impact one organization or another. So the creating instrument or legislation that created you, that's the very first influence that you have to know. What are you incorporated under? What legislation in what jurisdiction incorporated you? And what does the instrument that you actually filed to create that organization, what does it say? That is sort of like your birth certificate. This is what you are. So you have to know what that is. Then the most important thing in that creating instrument that is key for nonprofit organizations, mostly across Canada, is what are the objects or what are the purposes that you stated would be what your organization is created to do. And nonprofits do have a unique situation in our country that they have to state that object or purpose. Business corporations that are intended to make profit, they don't have to state those purposes. They are just generally assumed that they're making a profit. But nonprofits, every one of you has a very specific object or purpose that you are intended to achieve. Then the next influence is the bylaws that you have or other similar documents that are the laws that your organization has adopted to govern your organization. Some bylaws are made under the very specific requirements of the legislation you are incorporated under, and some bylaws have a little bit more leeway to create different kinds of laws for your unique kind of organization. Again, a lot depends on the legislation you're incorporated under, and I'll talk about a few examples in a minute. And then finally, the policies and procedures. So what policies and what procedures have you created for your organization to follow based on the bylaws generally and your unique needs? Your objects or purposes might dictate things you have to do. And overall and overreaching is your creating instrument or the legislation you're incorporated under. So these are your internal influences. So each of your organization has an influence that you need to understand before you know what governs you. Then, unfortunately, we can't just be our own little island. We have, as we do as individuals, we have many external influences that we have no control over because they're external influences that are putting pressure on our organization. So the most important one I always talk about when I deal with nonprofits and charities is the federal legislation, such as the Income Tax Act. The Income Tax Act has far-reaching consequences and regulates charities. I think you know that that's a given, but it also regulates nonprofit organizations that are incorporated under various pieces of legislation, such as our Alberta Societies Act, Companies Act, Canada Not-for-Profit Corporations Act. So the Income Tax Act does have something to say about what you can and cannot do or what you can or have to report. Then there's provincial legislation. We're here in Alberta. So in Alberta, we have the Charitable Fundraising Act, which governs fundraising for all organizations in Alberta, whether or not they're charities or not, whether they're incorporated or not. So that's a far-reaching piece of provincial legislation that influences the fundraising practices of an organization. The Occupational Health and Safety Act is another piece of provincial legislation that it has a strong influence on many organizations because it applies to your organization, whether or not you're a charity or a nonprofit. So you need to follow, as many businesses have to, you need to follow the rules in that piece of legislation. So that's a very strong internal or external influence on an organization. Then, of course, if you're in a municipality, you are governed under bylaws that the municipality itself makes that govern what happens inside its municipal boundaries. Um, most charities and nonprofits are funded by someone, and you may have funding agreements that very specifically dictate what you can and cannot do as an organization, whether generally or with the funds that the funder is giving you. So this is a big external influence on an organization, especially if you want to maintain the relationship with that funder. Plus, there's so many more external influences that govern an organization. Too many to list, but you just put on your thinking cap and think about what impacts you as an individual and say, does this impact me as an organization, volunteer, director, employee, etc. And I bet you could come up with a bigger list. So I have to set the scene because when we're talking about the liabilities of directors who are the governors of the organization, those individuals need to know, well, what governs our organization in the first place? So here's a little summary here. First of all, you have to really know what your incorporating legislation is. You really do. In Alberta, are you incorporated under the Societies Act? As a nonprofit society, are you incorporated under the Part 9 of the Alberta Companies Act? Are you incorporated under the Canada Not-for-Profit Corporations Act and then registered to do your activities in the province of Alberta? There's are you incorporated under a private act of the legislature of Alberta? Something has created you and you need to know what that is. Then, of course, you're incorporating documents. You have to read them, and some of them have been amended over the years, so you have to read and understand any of the amendments. To understand your incorporation documents as amended is key. Bylaws, well, those are the laws that your organization has adopted for itself, and those are laws that you are allowed to make based on your incorporating legislation. And then under your bylaws, which are sort of your laws, you have your policies and your procedures that tell you how to comply with your laws, your bylaws. And these are helpful things that give every organization very specific details on what they can and cannot do at the really micro level. And then, of course, we talked about other laws and regulations that are out there that, depending on your specific organization, you may have different kinds of laws that impact you that are enacted by various levels of government. So that's the big progression of what you need to know before you can safely understand what actually governs your organization. So other presentations I do very specifically talk about the fact that the governors of your organization are the directors, and this comes from many centuries of basic law. So this is why we're talking today about the directors and their duties and their liabilities. And in Alberta, we still have to look at the common law. And the common law is the laws that the courts have made over the centuries that we have brought into Canada, into our legal system. And the common law is still there as the law unless a legislative amendment to the common law has been made in the jurisdiction. So unless Alberta has made a law that changes the common law specifically, then the common law will apply. So that has something to do with directors' responsibilities in Alberta. But at common law, each individual director on the board of an organization such as the one you're representing, they have a couple of fundamental duties. They first have a fiduciary duty to the organization, which I think you've heard these terms before. The first one is the duty of care, which is to deal with the organization and act as a director with competence and diligence that, and I've got this underlined here from, because this comes from the common law, that a reasonably prudent person with similar knowledge and expertise would exercise in comparable circumstances. So I've underlined reasonably prudent person with similar knowledge and expertise because the Alberta legislation, the Alberta Societies Act and the Companies Act have not changed the common law on that. And that specific sentence talks about someone with similar knowledge and expertise. So when you join a board of a society or company, for example, if you have special talents or special expertise, such as legal or accounting or medical or something that you're bringing to the organization, then you certainly are bringing those skills and talents, and your standard of care is based on a person that has the similar talents and skills that you do, not just the skills and talents of every person on the board, but a skill and talent of that specific kind of expertise. So that's a key to remember. The duty of loyalty is the second duty that all organizations, directors have, and that is to act honestly and in good faith in the best interests of the organization and not in the interests of the actual person who is a director. So I think you've heard these before, and there's centuries of case law about these specific duties. And one thing I do mention is that these duties of directors of nonprofit organizations, corporations, are the same duties as business corporations directors. So there's no excuse that says, well, this is a nonprofit, so therefore I don't need to worry about these things. That's not what the law says. So you have to remember that. Now, in Canada, we have some modern legislation that has changed the common law. And that doesn't apply to you if you're an Alberta society or company, Part 9 company that's incorporated, but it does if you've incorporated or you are incorporated under the most modern legislation that we have for nonprofits in Canada, which is the Canada Not-for-Profit Corporations Act. And they have codified or put right in the act the statutory duties of directors. And you'll see the list here: the duty to manage or supervise management, act honestly in good faith. That's the duty of loyalty. And then the fiduciary duty, the exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. That's one of them. And you see, I've underlined reasonably prudent person because they've done away with the what we call the subjective standard of care of you're bringing your skills to the board, to the objective standard of care that you are bringing skills just like everyone else. So just because you have special skills, you're not going to be held to a higher standard on these boards that are incorporated under the more modern legislation than you are if you are incorporated under the legislation such as the Societies Act or the Companies Act that does not change the common law in that regard. So generally, that's something we gloss over here in Alberta, but it's something that if you are a professional and you are asked to sit on a board of directors, that you should think carefully about your specific skills and what your duty is going to be, bringing those skills to the board. And of course, the Canada Not-for-Profit Corporations Act does go on and on about other duties of the board. You have to comply with the Act, and you have to verify the lawfulness of the articles of incorporation and the purpose of the corporation. So there's a few other duties that are specifically described in that legislation that are helpful. And it does also codify the due diligence defense and good faith defense for directors and officers. So, which is cases and cases in the common law, mostly from the business corporation side, but there are some nonprofit organizations that have been the subject of court cases where they look at the diligence that the directors of a nonprofit organization have taken, and the directors have acted in good faith. So the Canada legislation actually codifies that. So let's go on and just talk a little bit about a few of the duties that I want to emphasize. They're the same as a business corporation, so or a for-profit corporation, as some refer to it. So the duty of confidentiality. So you're sitting around the boardroom table of a nonprofit, and you're talking about litigation, employment matters, donor lists, the board discussions, what you're talking about, or even how someone voted for or against a motion around the boardroom table. So those are just as confidential for you as a director of a nonprofit organization as they are for a for-profit corporation. And the same with your obligation to disclose. If you have no obligation to disclose what has been said, unless, of course, it's required by law. So the same requirements for for-profit corporations apply for not-for-profit or nonprofit corporations. And then the duty of loyalty really is about conflict of interest. And at common law, the conflict of interest provisions basically say that a director cannot benefit from his or her position. So the general idea is that directors must declare and avoid any conflicts of interest and refrain from voting, or they may have to resign if the conflict can't be overcome or dealt with easily with the organization that they're dealing with. And they cannot receive remuneration for acting as a director. So in Alberta, just so you know, there's no specific requirement that you can't receive remuneration for acting as a director in our statute. In fact, the Societies Act, as you know, asks you in your bylaws to tell the corporate registry in your bylaws whether or not directors will be paid or not for being directors. Generally, they're not. Generally, they're not. Why? Because of the common law position. And specifically, if your organization is going to be trying to get charitable registration, that is one thing that charities directorate or the Income Tax Act, relying on the common law conflict of interest duties, say that you cannot receive remuneration for acting as a director. We're not talking here about receiving remuneration or payment of directors for acting in other capacities. We're just talking about being paid to be directors. Most for-profit organizations pay their directors. So sometimes non-profit organizations say, why can't I just be paid too for being a director? All these meetings. So these are things you have to think about as a nonprofit organization, and then the overlay if you are a registered charity. There's a few other things about being a registered charity that add to the duties and liabilities of directors. So the Canada Not-for-Profit Corporations Act codifies, again, the rules for conflicts of interest situations. So it's very good because modern, you have a conflict of interest around the table at a Canada Not-for-Profit Corporation. You have to very specifically follow the process that is laid down in that legislation. The Societies Act is silent on that matter. And in Alberta, the Companies Act has a process as well that is not as modern as the Canada Not-for-Profit Corporations Act, but there is a process laid down in the Companies Act for disclosure of conflict of interest that directors might have. I'm really going fast on this. This is each one of these slides is the subject or could be the subject of a whole other presentation. So generally, the purpose of this is to raise issues with you and maybe uh, encourage you to seek information if you have any issues or thoughts about any of these situations that might apply to you or your organization. So there are external liabilities of directors that come from legislation that has nothing to do with the fact that you're a nonprofit. This applies to many organizations, individuals, uh, and they directly impose liabilities right on the directors. So the Income Tax Act, the Excise Tax Act, our GST Act, our Canada Pension Plan, all of those, I think you know that, if you don't pay the government, the Revenue Canada, are your remittances, your withholdings, etc., that the organization is liable. Well, the Income Tax Act and the other regulatory statutes go further and make the directors personally responsible for those failures on the organization. So there's that very big liability, and that's the one people often talk about. The Canada Not-for-Profit Corporations Act and the Companies Act here in Alberta specifically talk about certain situations where directors of a corporation or a Part 9 company are liable for wages, unpaid wages that the organization itself hasn't paid. A big one is environmental protection legislation. You may be aware or have heard stories about directors of for-profit corporations being held responsible and fined for environmental protection offenses under the legislation that is in existence. It's the same for nonprofit organizations that have environmental protection needs and they fail. So that's another one that people sometimes don't think about, but it doesn't apply to every organization. But if you're in that area where the EPA legislation does apply, then you need to make sure that the directors know that they could be responsible for certain things under the legislation if the organization is not doing what they're supposed to do. So occupational health and safety legislation, I talked about that earlier, about one of the big external influences on nonprofits in Alberta, and that has lots of liabilities that they could impose on directors of organization. Anti-terrorism legislation, that definitely where the buck stops is the directors of the organization, and there are sanctions in that legislation. And again, we could brainstorm and we could go on and on and on and come up with other legislation that talks about the responsibilities and the liabilities and the administrative penalties that can be assessed against directors of corporations, whether they're nonprofits or not. And a lot of it depends on the kind of organization you are. I mean, one that deals with environmental things, of course, has one concern. If you're dealing with youth or children, you may have other concerns. All of these depend a lot on the kind of organization you are. So I'll pause there for a minute, and then I'm going to talk about, this is great, but how do we protect ourselves from this? This is the good news part of the story. So if there have been any questions that are important at this point, Sandeep, you can interject.
Sure. Thanks, Yvonne. We have had a few questions along the way.
Okay.
And if they don't feel relevant at this point, you let
Yep.
me know and we'll circle back at the
Okay.
end here.
Okay.
Julie has asked, should we allow members to vote and motion on financial decisions when they are not legally liable for those decisions?
Okay. Sure. That's a great question.
Okay.
Because what your members can vote on often depends on your legislation and your bylaws. So, you have to look. I mean, should you? Well, you have to if your influences, your governing documents say you have to. And do you have a choice as to what your bylaws and governing documents say? Well, you have to look at the legislation to see if there's any restrictions. The Canada Not-for-Profit Corporations Act does have, certain member powers. So does our Companies Act and the Societies Act. So you need to know all those little bubbles. Go back in the bubbles to answer your question.
Wonderful. Thanks, Yvonne. Another question we have: how does the duty of loyalty apply to individuals who
Mhm.
sit on multiple boards where the
Mhm.
interests may conflict?
Yeah, and that's good. That's a good question, and that's where the conflict of interest comes in. So every one of those boards that they're sitting on probably has a conflict of interest policy, and if they don't, then the common law will just come right in and say this is what it is. If it's common law applicable, if it's legislated, so each of those organizations is like a separate thing. It's a silo, and you have to comply with each one of those conflict of interest requirements in those different organizations. Some may say if you sit on another board, you can't sit at all on ours. These are all very good questions, but they should make you think before you take on a board job, or if you have the ability to make policies in your organization, you could very clearly say if you are on another board that has a similar kind of object or purpose, then you cannot sit on our board, or you don't say it like that. You just say you're not eligible to sit on our board. So this is something that can be managed. There's no law that says anyone's entitled to sit on any board they want. So that's where each individual organization has to take matters in their own hands and make their own laws as far as they can make under their legislation that incorporated them. That's a
Hmm.
good question.
Hmm. We have a comment and question here. I am not sure if you can speak to this. This may be an unfair question. You mentioned the OHS Act.
Yes.
What is your perspective on WCB coverage to
Mm,
mitigate risk? We have
mm,
been told we are exempt but could opt in. We have general liability and D&O
mm,
insurance. Is there value in having
mhm,
WCB as well? It is costly, but I'm wondering about the benefit of protection. So maybe one of those
yeah.
ones that's a bit more specific to
Yeah.
your situation, and we can. I'll provide some more
Mhm,
information about how to set up a consultation or clinic
mhm.
with Yvonne, but I did want to just acknowledge that
Yeah.
that was shared in the chat.
Well, thank you. Yes. I mean, these are all really good questions, and they're all so specifically dependent on many things that are influencing your organization. So these are questions that can be answered by looking at the information and getting some good information to enable you to make the decision. So that's a good question. And I'll talk about insurance and indemnities in a general way here before we end. Okay, so let's talk about liability protection. And this is very interesting because this is in Alberta, we're an outlier that has this statute. It's called the Freedom to Care Act. It was enacted in 2021, and it was intended to give volunteers sort of comfort that if they did their volunteer job, that they wouldn't be personally liable, meaning put their own personal assets at stake in case if something went wrong. So the liability protection is for all volunteers generally, but today we're talking about directors. So I wanted to make sure that I specifically mention that it's for volunteer directors, officers, or trustees of a nonprofit organization as defined by the Act. So it's got to be a corporation. So these are interesting um, liability exemptions because generally, if you're a volunteer, a director, you're a volunteer, and you should feel some comfort that this piece of legislation is covering you in Alberta. So let's talk a little bit about the specifics. And I must say, the source here, the government of Alberta, has put all sorts of information up on their website when this statute was enacted, and the link is in the materials here. So please look at that. So what is protected? So what is protected? It's providing protection from liability for volunteers, and it's removing any potential barriers or concerns that they have for to volunteering, and that's the intention of the legislation. As I said, it's got very broad liability protection for volunteers. However, it's only for those volunteers who are acting within the scope of their duties on behalf of an organization. And when this legislation first was enacted, that was key to understand. And I'll talk a little bit about the first case. And indeed, the scope of duties is the key to protecting your volunteers from liability, or if you are a volunteer, protecting yourself from liability, to make sure that you have the scope of duties, your marching orders, and you don't go outside what your marching orders say you should do as a volunteer. So it goes on and defines the volunteer as not being compensated for their role. So, no honorariums, none of that stuff, but you can get reasonable reimbursement for your expenses. So if someone who's very clearly just paid an expense account to do their job, their volunteer job, is a volunteer if they're not receiving any other remuneration for anything that arises out of their volunteer role. So you have to really protect this. This is so key and the cases will look at this, look at the very definitions in the legislation when they have to decide whether someone is going to be liable or not. So what's not protected? Well, this is common sense, right? This is what usually doesn't get you anywhere in Canada. So if the damage that you do as a volunteer is willful, reckless, or criminal, or gross negligence, which are all terms that have been defined in case law over the years, then you're not going to be protected. If you are operating a motor vehicle when you're a volunteer and something goes wrong, that's not going to get you out of liability, because you're expected, of course, you're going to have other insurance, your own car insurance, to do that. If it constitutes an offense, so if you're doing something illegal, like a criminal code offense or even a provincial offense or some other offense, think about, maybe the Occupational Health and Safety Act offense, then you're not going to be protected. And if you're impaired, of course, no protection will be availed to you as a volunteer. So this is the good news for the volunteers, okay? So as long as you're not a bad person and you're acting within the scope of your duty, you're not going to be personally liable for your actions. However, I want to make sure you guys know, especially if you are governors of an organization, that this does not affect the liability of the organization itself. So the organization is still responsible for the act of its volunteers. This is just the volunteer will not be liable. So you have to think about this. And the Act makes it very clear that the nonprofit organization itself has no right of recovery against the volunteer if the volunteer is not liable. So, when we're talking about duties and liabilities of directors, we know what our duties are. We know we have to act in the best interest. We know we have to do all these good things. And as long as we're doing it within the scope of our duties, and we're doing what we're supposed to do, we're not driving a car, we're not being criminal or impaired, then we will not be responsible to pay for the damage. However, the organization will, and the organization cannot recover from us. So very far-reaching legislation. And we have a case. After a couple of years, we have a case. And this was a case where a president of an Alberta society was claiming, and you can read the case if you want, was claiming that they were not liable because of this act. And the judge in this case, and this was a recent case, so it's unknown whether there's going to be an appeal or anything, but the judge found that because they were not acting in the scope of their duties, and one of the duty we've talked about is duty of loyalty, they couldn't use the freedom under this act from liability. So, in the quote I thought was very appropriate in this case, actions taken in breach of a director or officer's common law duty of care and fiduciary duty to an organization are the antithesis of acting within the scope of their responsibilities. So, remember I talked about the common law, and the Societies Act didn't change the common law. So you have to look at the duties that the law imposes or offers or gives a director of a Alberta society from the common law, because the Societies Act is silent on it, remember. So that in this case, the Freedom to Care Act did not insulate her from liability. So I take away from this case, which is something that I was hoping to see some certainty, that the most important thing is knowing what the scope of care is of the volunteer as a director, and making sure that they understand what it is and the organization knows what it is, have it in writing, and there make sure nobody goes outside the scope or acts inappropriately, and there will be freedom from liability personally. However, of course, as we know, it doesn't protect the organization. We'll talk about that in a minute. I like to talk a little bit about indemnities in the context of this, because you often see in legislation or in bylaws, and indeed the Canada Not-for-Profit Corporations Act specifically talks about indemnities for directors. Our legislation is generally silent, but an indemnity is when an organization basically enters into a contract with a director or anyone else, but we're talking about directors here, that they will make good your liabilities if something goes wrong. So if the director has to pay something for damages or something else, then the organization will indemnify them, meaning will make good in what you've had to pay. Now that is a contractual relationship. Sometimes you see these clauses in bylaws. I always suggest that if you as a director or a volunteer want to be indemnified just in case you're found liable, even though the Freedom to Care Act may protect you, then you really should focus on having that contract relationship between you as an individual and the organization. Um, it's key, but it also depends on whether or not the organization has the ability to enter into an indemnification contract. Sometimes the governing legislation talks about it, like I mentioned, the Canada Not-for-Profit Corporations Act. Sometimes your bylaws talks about the kind of indemnity an organization can enter into. The big one is the ability to pay. If the organization indemnifies you for $1 million in case something goes wrong, well, what if the organization doesn't have $1 million? You've heard the saying, it's worth the paper it's written on. So indemnities are nice, but they're contracts. So look at whether or not it's going to be of any help to you as a volunteer or not. So where does the money come from if something has to be paid out? And of course, insurance coverage is where we're going to talk a little bit here about coverage, because defending a cost, an action, even when you're claiming the Freedom to Care Act, you've got to get to court first and claim these things. There's lots of coverage for directors and officers, covers a broad range of things. You need to make sure that your organization and you as a director or officer of an organization, that you are comfortable with the insurance coverage that the organization has. So the Freedom to Care Act and how it interplays with insurance is an interesting one. I won't get into that, and none of the cases so far have talked about that. But think about the kind of insurance that you have for your directors and officers if you're governing the organization, and if you are about to join a board or something, or do any review of your insurance coverage, make sure you understand what is covered Read the fine print. Read the fine print. Look at the riders, the exclusions. Look at the kind of organization you're actually governing, and make sure that the insurance coverage is appropriate for what you're doing. That's why you should discuss all of this with your broker or your agent that actually has helped you secure the insurance coverage. And if you don't have insurance coverage, well, you should find a knowledgeable broker in insurance and talk about all these issues with them and get the appropriate coverage. It costs money, but so does all insurance does. So in the last few minutes before questions, I just want to give you some other resources for risk management to protect your directors. Due diligence, we've talked about that. There's something else in the cases called the business judgment rule. And all of these are defenses to what directors do, but they require a record. So you have to record everything, meaning that's why minutes of meetings are so important, because if you don't have minutes of meetings recording a decision, then really it's just like the decision was never made. So you have to keep your records, and just put enough information in your minutes that you record the decision. You don't need to go on and on and on about many other issues. Old records, you have to maintain them. Corporations never die, so their records should be kept forever. That's generally the rule. So you have to make sure that you have records that have been maintained. So that's the biggest protection for directors, is to make sure you can, you know, prove that you made these decisions and you made them based on your due diligence or the best information you had available at the time. Lots of case law on this one. For-profit organizations, same thing. All those laws apply to nonprofit organizations. So the other thing, of course, we've talked about having job descriptions for directors. What is my job description? What is the scope of my duties? Board orientation and education goes a long way. Don't let directors assume things when they join a board. You should educate them and orient them about all my little bubbles there, the legislation, you know, the bylaws, the incorporating documents, the policies and procedures, and talk a little bit about other influences that will give them a good grounding in what they're about to embark on. Make it a board agenda item. So every agenda, talk about some other kind of risk that the organization is facing and deliberate on it and make any decisions you have to take steps to avoid the risk if you can. The committee roles, the committee plays a role. The board committees would play a role because they're the ones that actually delve into these issues, the risks that the organization is taking, and potentially make recommendations to the board to make a decision. Review your governance practices. Always keeping the risk that your organization has in mind, because regardless of whether or not you have the Freedom to Care Act, nobody wants to go through the hassle, or insurance. Nobody wants to go through the hassle of being accused or being involved in a lawsuit that relates to what we're talking about here, is the liability of directors of a nonprofit organization in Alberta. There's lots of ways to prevent it. And there's lots of resources for you too. You don't have to reinvent the wheel. CPA Canada, they have wonderful publications, and if you use these as a tool at your board meetings, you're going a long way to manage the risk and manage the liability of directors. So there's questions about overseeing management of risk. There's 20 questions, and then there's one specifically about directors' duties, and they go into great detail about many of the things I've talked about today. So please use those resources. They're free. Integral.org also has a risk management toolkit that it's an interactive toolkit. You can go on our website and use it, and it asks some of these questions and makes you think about these things and gives you a little report at the end. So these are very good tools, and there's other tools like it too, but use this one specifically for nonprofit organizations in Alberta. So here's just a little view of some of the slides that we ask on that toolkit. And if you have any comments about the toolkit, we'd be happy to hear if they've been helpful to you. Talks about the Freedom to Care Act too. So that's really quick. I wanted to leave some time for questions and further discussion, and a very, very high level overview of directors' liabilities of nonprofit organizations in Alberta. Very, very high overview. And thank you for listening. And I look forward to talking to some of you again.
And we have a few questions here in the chat for you. A comment here, would an honorarium be considered compensation?
Well, that's really an accounting question, but it's money, isn't it? It's not reimbursement for expenses. It's payment, right? So this is where you get into the facts, right? If you're in court and someone says, "Are you a volunteer?" Yes. Did you get paid? No, I got an honorarium. Well, what is that? Oh, it was money, or it was a gift card or something potentially. I mean, this is where, is a gift card cash? These are all things that could just be bogged down in the whole process of whether or not you are a volunteer or not. And I've had to give this a lot of thought lately because of the whole the case we just talked about and other cases that potentially could come up in Alberta. And if you are called upon to prove you're a volunteer, how do you prove it? Well, you prove it. You gave freely of your time without expectation of anything in return. And if the job description says, and you will be paid an honorarium, well, then you know that you're not doing it with no expectations of return because you signed up because you knew you're going to volunteer and get an honorarium. So ask your accountant, but honorariums that's money.
Okay. We have some questions here from Rebecca. Is there a general preference for what type of minutes might be best? Formal, informal, action, discussion, verbatim. Understandably, this may vary based on group and purpose, but is there best practice? What are your thoughts on AI minutes as backup for internal use? There's another one from Rebecca that I'll relay to you after you've had some time to share your thoughts on this one.
Okay, well, minutes really are the evidence, right? Organizations can only speak through its records, right? Because an organization is not an individual. It's an entity that is separate from the individuals. And how does it show what it does or what it did? And the answer is the documented evidence of what actions it took. And why it took those actions might be important. So how does this relate to minutes? Well, you want to make sure all your decisions are documented because that's the only way you can prove that someone actually made a decision. And then if you feel there's a reason to justify that decision, then you should have a little bit more about why you made the decision. So all of this is to say is that you should put the minimum amount of information in your records that would be required to prove something, whether it's a decision or a reason for the decision, and think about all the other flowery stuff you're putting in there and ask, what's the purpose? Is it harmful? Is it going to be helpful? It's really an interesting question, but it's each individual specific organization's needs, and you should make a decision. It's very important, and I know many organizations don't give this much consideration. It's important that you think about the kind of minutes that your committee or your board is going to be uh, um, happy with, and then adopt a template or adopt something, and then everyone has to stick to that. So it's all about evidence. So that's
Great.
one thing. And AI, well, I guess my thoughts on that is AI summarizes, but my thoughts are, where is that information being stored? So if you use AI just for minutes and it summarizes, somewhere the whole thing is stored somewhere. So, I mean, we're at the frontier of AI right now, and it's unknown what would happen if someone said, well, here's our minutes. And the question is, well, was it recorded on AI? Yes. Okay, we'll bring the transcript in or bring something in, because that's the evidence we're going to look at. Oh, look at all these people who said all these things. So I don't know. You need to manage the AI process, and that's a bigger question than what we can deal with today. But it's definitely going to change the way people do things, I think. So this is
Mhm.
just one place, and that's minutes of a meeting.
Mhm. The follow up here from Rebecca, and then we have a question from Kevin and Reynolds. So Rebecca says, regarding professional development, you've mentioned it's important to encourage professional development and training. However, is there a way this can be mandated of a board or new volunteers? Would this be in addition to policies and procedures? What frequency?
Well, an organization can mandate anything that they want, right? I mean, it's your organization. And if in your procedure is that all new directors or volunteers for that matter have to go through this training, then that's your prerogative. It's your organization. So you could put it in the your bylaws. Qualifications of directors are this, must be 18, must be a resident of Alberta. I don't know. I'm just making things up. Must go through level 1, 2, 3 of whatever, CPR or something like that. I mean, these are all things that you can put in your bylaws if you really want them to have teeth. But if you want to make them changeable or a little bit more flexible, then you could say, and complies with any other requirements that have been set down by the board of directors in their policies or procedures with regard to the qualifications of a director. And then those qualifications, your procedures, that's where you state they have to have certifications, or they have to attend courses, things like that. So remember, this is your organization. So you make the rules unless someone else has made the rules for you. This is one of the internal influences that you're going to impose on your organization because it's for your benefit before an external source imposes it on you. So that's a good
Hmm.
question, Rebecca, for sure.
Thanks, Yvonne. Kevin says, what opportunities or risks are there to decolonize boards and governance without increasing risk to make it more accessible to people who may not have the standard experience or expertise to join a board?
I don't know what decolonize means. Well, in this context, what do you think that means? Or maybe
Kevin, if you'd like to
yeah,
pop a comment in
yeah,
for clarification, that would be
yeah.
wonderful.
What
In the meantime,
mm-hmm,
I will move on to
mm-hmm.
Reynolds. Is legal counsel recommended to be on a not-for-profit board or on retainer as another form of due diligence?
Well, legal counsel on a board of an Alberta society or a Part 9 company brings the standard of care of a lawyer to the board, which is pretty high if it's a corporate thing, or uh, the lawyer has expertise in certain area of law or governance. So that's you may have reluctance there, but it's obviously good to have any professionals on your board for other reasons. Um, having legal counsel on retainer, well, it's good if you can afford it, but uh, why? For what reason? Really, it's the does the board need the advice, or does the operations need the advice? Um, And is that, justified? Are these justifiable expenses? If you're a charity, for example, is that part of your charitable purposes and activities that you need this, or is this an administrative expense? You have to think about all these things. Many factors. There are many factors here. But hopefully organizations like Integral.org or other organizations that offer assistance to nonprofits can help you with some of your questions, and that's important. You need resources, and AI and Google maybe not be the best resource at this time yet. I mean, don't forget we're in Alberta here, so Alberta laws are a little bit different too than other provinces in many
Mhm.
respects. So
Yeah.
hopefully that answers your question, but there are resources for you out there.
Kevin has made a follow-up comment
Okay.
here. People outside of the standard board matrix, i.e.,
Mhm,
boards are often legal and accountant heavy, of which
mhm,
marginalized groups are
mhm,
usually underrepresented. Is there a way to decrease that ratio without increasing risk? I'll
mhm,
just make a comment here. Kevin, I
mhm,
think this is a really great question and interest in the DEIB
mhm.
space of how to
Okay.
balance.
Mhm,
Um, what it sounds like recruitment practices here. And
mhm,
so there's definitely room for this conversation. Not today, since we are
mhm,
at our time, and this is a nuanced conversation, I believe,
mhm.
which is specific to your organization, what your DEIB initiatives and conversations have been thus far, and how to kind of broaden those while keeping risk management
Mhm,
in
mhm,
mind. And so I'm
mhm,
going to share just in the next couple of slides here a way to connect with us for a consultation or a follow-up conversation regarding any of the things that have come up today. I would invite you to reach out to us, and so we can continue having this conversation with you for sure. With that, thank you, folks, for joining us today. And Yvonne, thank you so much for taking the time to share your expertise and perspective. I'm going to share a link here for a short feedback survey. As we think about the education offerings that we bring forward, your feedback is critical as it informs what your needs, interests are, and helps us know that our offerings and different programming is on the right track and relevant to you. So if you could spare a few minutes just to provide us some insight and feedback, that would be greatly appreciated. Um, there's been a number of comments that have come up during today's conversation that are quite specific to the organizations that you folks belong to. And we recognize that these require more in-depth conversations. And so for more specific support, including legal information tailored to your organization's needs, we encourage you to access one of our free problem-solving services. And so this could be a short phone or video consultation or a 1 hour long problem solving session called a clinic. These meetings happen between your team and one of our integral org experts. Clinics and consultations are part of our mission to educate and support Alberta nonprofits. So we are here to help. You can find out more about this support by visiting our website or by giving us a call. I'll drop a link here in the chat for the clinics form. And you can fill out some more information there and begin that process if you think that is something that you would benefit from. Integral Org is a capacity builder and nonprofit ourselves. Our goal is to equip you with the knowledge and support you need to do your best work. And we work in many core areas, including governance, strategic planning, risk management, legal compliance, financial management, leadership development, and more. And we work with nonprofits at any stage of their life cycle using a multidisciplinary approach to address your most pressing concerns. We're here to walk alongside you and your nonprofit development journey, so please do not hesitate to reach out to us. We're more than happy to have these conversations with you. It can be an informal conversation, just a chat, or you can access more of a formalized process like one of our legal clinics. We're here to meet you where you are, and so we welcome any follow up or inquiries. All right, with that, I hope you have a wonderful rest of your day, and we hope to see you again soon at another workshop or gathering. Thanks so much, folks.
Bye, everybody.